this week on Sunday on the LGBTQ community. Um, so you guys shouldn't have any problems. Are there any questions about that assignment thus far? Your assignments came in really well last time. As you can see, many of you did really well. The one thing that I would like to add is some of you guys are forgetting the subheadings. Please don't forget the subheadings when you're using your template. That just reminds you that it shouldn't have just one heading at the top. It should have continuous headings throughout the paper as the subheadings to the topics as you're answering those questions that are involved. And those subheadings can be titled any way you want as you're kind of opening up that section. All right, so this today we're going to be talking about negligence and duty to warn. Let me share my screen. Okay. So what we're doing is trying to understand what is our responsibility for negligence and duty to warn, what as a school counselor. So we'll go over these things, understanding what malpractice is in school counseling, identifying standards of care, what's important, explaining what is in loco parenti, and then listing 4 elements of negligence and discussing negligence prevention and reviewing ethical laws, standards for competency. So, negligence is the breach of duty that is caused by harm. It's a civil wrong where duty is owed to another, is breached. Okay, so the breach must be a failure to meet expected standard of care, and there must be a causal connection between the breach and the injury that is suffered. So there has to be a connection between those two in order for that to really, for it to be definite negligence. Um, Damages or injuries to the student or parent must result as a breach of that, and that they common in school counseling when a counselor fails to act reasonably to protect the student. So we're talking about reasonable, and when we're talking about reasonable, we are talking about what any other school counselor would do in that circumstance, right? So we're polling all of the all of the counselors as we use our ASCA national standards, and that what would most of them say? What would the majority of them say in that situation? Malpractice is a specific type of negligence, which involves professional services. It occurs when a counselor fails to provide services consistent with accepting professional standards. And malpractice claims often arise from dissatisfaction or communication breakdowns, not always substantiated grievances. Expert testimony is often needed to determine this professional standard was breached, and that school counselors have to adhere to ethical and legal standards to avoid malpractice suits. Okay, so these are some things that we have to keep in mind. Again, we're going to kind of go over some of the themes as we go through the chapters, and later on, we will go over an actual court case. And I'll share with you like another way, a way of researching and getting documentation for a court case that's not in our book. So the components and standard of care is duty, which establishes the legal obligation of a school counselor to act reasonably towards a student or a parent or a guardian based on the relationship or responsibility, such as in loco parenti. So a lot of times, school counselors are named in the bullying because they feel that they should have acted reasonably to do something to stop bullying from occurring. We'll talk about that a little bit later. Clear duty relationships, awareness of responsibility, and documentation of role and obligations. Sometimes school counselors are thrown out of court cases during the assessment because they found out that they were not in their role. So sometimes lunch duty, if it's your everyday role as a school counselor to do lunch duty, and something happens during the lunch situation, then you may be it's part of your role. So then you could be named in the lawsuit. However, if it's not your role, let's just say that you just kind of go into lunch duty just to connect with your students, meet with them, or but it's not your everyday responsibility to stop harm from occurring, then you could be thrown out of a lawsuit for that reason because once they determine that that's not your major role, that your role is you just kind of stopped in and talked with them because they're all gathered together, then you didn't have any duty there. And so therefore, they will go ahead and dismiss you from that particular court case. Breaching occurs when the student counselor fails to meet expected standards of care, judged by reasonableness and adherence to professional and district guidelines. So this comes, suicide prevention falls under this category. And when we're doing suicide prevention, that's when we are making sure that it's our role and our role as a mental health professional on campus to train and be the expert in that role. And then as we're the expert in that particular role, then what is our judgment? What does our judgment say? So we can't take it lightly. We can't dismiss it because if we're named in our school policy, and like I said, for California, it is required that you have a school policy for school counseling. I mean, I'm sorry, for suicide prevention and intervention. So if you are named in that suicide prevention and intervention as a key role and factor, you're always the last stop. So if you miss a step in that role, then that is problematic. And that's what you can open yourself up to a suit for that. Hold on just one second. Sure. Oh, brother. Okay. Hold on. Somebody's trying to get in and I can't see them. I thought that's what was happening. Um, Looks like four people are trying to get in. There we go. All right. Welcome, everyone. We started. I'm sorry I didn't see you. Thank you for texting me, Jimmy, because I otherwise I didn't see that pop up with all these different things that are on there. So we're talking about chapter 5, which is negligence. I'm recording, so um, you guys can go back and kind of look at some of the slides if you've missed it. All right. So we're on breaching and what breaching means. So we're talking about we need to identify the duty breached, we need to assess actions against standards, and we need to document documentation of the deviations. Okay. So this is where something that we talked about when there's a threat assessment, and a threat assessment doesn't fall under our category. As I was talking to you earlier about suicide prevention, that does fall under our category. Usually we're just a person that is on the team for a threat assessment. And when we're doing a threat assessment, that's because a student has stated that they would cause harm to someone else, right? And when they want to cause harm to someone else, or they say they're going to cause harm to the whole school or something to that nature, then as a member of that team, documentation is important. Now, some of the lawsuits that have occurred here in California with documentation is since there's no legal course of documentation, if you create one, An example of that is, let's say the school district decides, okay, everybody has to fill out this form whenever there is a threat assessment, right? And so you're training everyone and whoever's on the threat assessment team, and then you teach everyone because there's no law for this. Um, if someone does not follow that guideline, let's just say it's a busy day and they don't do the documentation according to what you have outlined in your handbook, what you have outlined at your school, then in that situation, you have opened yourself up to a lawsuit. Okay. Because at that point, everyone is trained. So what a lawyer would do at that point is go back and say, well, it says right here in your handbook that you train everyone on how to do a threat assessment. It says that you will take these specific steps when a threat assessment happens. And it says that you will do these following things when a threat assessment occurs. And if you specify that and someone misses a step, you can see where that could cause a lot of problems, because especially if someone was injured in that, let's just say a shooting did occur, something did happen, then that would be problematic. And that is where a person, a school district would um, face a large lawsuit, especially with the loss or death of anyone involved in that threat, and the threat was carried out. Now, because there's no legal requirement in the state of California for that, you kind of just want to document. And the word document just means take notes. So as long as you've gone through and there's some guidelines on some questions that you can ask during a threat assessment, as long as you document, it could be on a piece of paper, it could be anywhere, and you take note and everyone is informed, director of people personnel services, a principal, all of the people that are involved, then you have met the legal limitations for that threat assessment. Okay. And I was comparing that to um, suicide prevention, because in suicide prevention, we are required to have policy and procedure. So, with that requirement, that state law of requirement, we must follow to the letter of the T. So, if we miss any step, if we forget to do something, we have opened ourselves up to a lawsuit, especially if a student attempts to cause harm to themselves at school, away from school, any of those things, and we don't follow the protocol or procedures that are in place. Okay. Causal connection. It demonstrates a link between the breach of duty and the injury or harm suffered by the student or parent, with the foreseeability of the harm being the key factor. So how much could we have seen that this was forthcoming? An example of that with the suicide is if they wrote notes before, if they did writings before, if they made comments before, and before could be like on an elementary school campus, you have students from TK to FIT. So anytime that they have been on your campus, if those threats have been made, and then so that's foreseeable harm, and then it gets carried out 2 years later, 3 years or five, then that's the foreseeable harm, because you've already have notation that the student had attempted or did something. So as long as you're following the protocol each and every single time, that's the foreseeable harm, right? Um, and then injury suffered, it refers to the actual harm or damages experienced by the student, parent, or guardian, which may be physical, emotional, or financial, and is necessary for negligence claims. Documentation of the injury or damages, assessment of impact, consideration of the damages, nominal compensatory punitive fee, or those are the examples. Another thing I was going to say was that in high school, we see this in the academic realm. In the academic realm, if we can be negligent if we don't follow all of the academics. Okay, one of the lawsuits that was mentioned was a student in Idaho that was lost their NCAA Division I scholarship because in the senior year of the very last semester, the student was missing a class. No, they changed the name of the class, the English class, from the senior English class to something else. And that didn't, now the problem wasn't that the class changed. Other schools had that same name for that senior English class. The problem was the school forgot to send that class change, name change to the NCAA eligibility. So it was never approved by the NCAA eligibility approved section. So that student then lost their Division One scholarship. So you can see where the injury that was suffered, the causal connection, the breach, and the duty, all of that together in that example. Oh, great. Hold on just 1 second, guys. Why? Okay, there we go. All right. In loco parenti, for school counselors, it is a Latin term that means in place of the parent. School and their staff, including counselors, legally stand as a role of a parent while a student is under their care. This doctrine imposes heightened duty of care on a school counselor to ensure student safety and well-being. And school counselors may discipline, protect, or make decisions similar to those a parent would make to safeguard a child. And the legal responsibility includes physical safety, emotional support, and acting in the best interest of the student while in school. So that is what we are doing. The 4 elements of negligence: duty owed, establishing the existence of a legal relationship where the school counselor owes responsibility to act reasonably towards the student or the parent. Breach of duty, it determines whether the counselor failed to meet that, whether they failed to meet that standard, the direct link, and injury suffered. Let me see what's going on. Okay, now here's some cases for academic advising, as I was speaking of. These are some of the court cases that were listed in the textbook. Brown versus Compton, the counselor's was immune under the government code, despite advising a student into a non-NCAA approved course, causing loss of a scholarship. Iowa Supreme Court remanded negligence case to trial, recognizing counselors may owe duty of care in academic advising, especially the NCAA eligibility advice. Wisconsin Supreme Court dismissed negligence claims due to governmental immunity, but expressed concerns over injustice and possible future changes. In Sane ruling impact, counselors urged to act as reasonably competent professionals, stay informed, empower students, and document advising carefully to reduce liability and risk and ongoing liability and immunity. The courts remain reluctant to impose liability for advising errors. Cases like Sane opened up potential negligent claims under specific circumstances. So we aren't really getting sued detrimentally to that, but we are being held responsible, and it's part of our professional requirements. So here's some recommendations: that we act with reasonable care, we stay informed and prepared, we empower our students and families, and we document and communicate clearly. So this is where all of our documentation comes into play. I remember when I was starting years ago, something that my administrator would tell me all the time: if you say it, it disappears in the air. But if you write it, it stays forever. So back then, that was where documentation was kind of getting us into a little bit more trouble, because people put a lot of opinion in their documentation. So what we had to do was learn how to be more specific with our documentation and just be very factual with our documentation, making sure you read over it carefully and you're not putting your opinions in your documentation, so that your documentation helps you to recall information and helps you to remember the cases. Because I'm telling you, after 28 years, it's all a blur. It just all looks the same. So you have to make sure that you keep good notes and notes that you can refer back to in case of any situation, and that you have, um, to refresh your memory about what's going on so that you can understand what you can say and what you should not say. Okay. Letters of recommendation, how negligence applies to that. It can be a legal claim if negative comments are perceived as defamatory and um, libelous without proper basis. Counselors should base recommendations on personal knowledge and when including negative points, when they're corroborating with multiple reliable sources. Many counselors focus on strengths, but acknowledge that omissions may imply weaknesses, creating a subtle challenge. And surveys show that counselors often face pressures with writing letters for students, even when they're trying, when they cannot fully endorse them. Fairness and caution are essential. If negative remarks are necessary, transparency and evidence are critical to protect the counselor and the student. So this is really important when we're writing our letters of recommendation. And this is I mean, this can happen if you're writing a letter of recommendation for a student that's trying to get into a prestigious middle school, a private school, anything like that, any type of letter of recommendation that you're giving. So it's just, you want to be cautious about that. When we're handling false information that's provided by a student, we need to rely on students to self-report extracurricular activities and achievements, which are often used in college applications. We're not required to verify every claim, but we should document any doubts or discrepancies when they arise. If false information is suspected, counselors may choose to investigate or notify admission representatives with substantiated facts. Counselors should maintain professional judgment and ethical standards when writing letters of recommendation, and that we should encourage students to be truthful while requiring contact information just for verification. And I think that kind of manifests sometimes when we're talking about um, those student services and the committees and school groups that they belong to. Suicide and duty owed. Okay, so we kind of already talked a lot about this, but the legal duty that's established in the case in our book on Cecil and Montgomery County Board of Education, it established that school counselors have a special relationship with students and owed a duty to try to prevent suicide whenever notified of a suicide intent. In local parenti, school counselors act with this, meaning they stand in place of the parent. So we need to make sure that we exercise reasonable care and protect that student when we're intervening with a suicide risk and situations. Duty to notify. I don't think there's any time where you don't notify. And I mean, even if they say, I was just kidding, this and that, you want to, express to the student the importance of them not doing that, but then also contacting the parent to let the parent know that you don't see any foreseeable risk because this is what they stated. But they should never just go home and they say, oh, I was just kidding. And you're like, oh, that's fine. You always want to make sure that you let them know, that the parent know, because anything else could occur. When they're with their parents. And if the parents didn't even know that they even said that during the school day, it's important. And balancing our ethical and legal roles. We're not, when we're assessing suicide risk, it is a challenge. Remembering that, like the ethical standards stated when we watched it last week for the webinar, we're not going to say low, medium, high risk because that doesn't, we don't have the ability to discuss that with the parents. But we're just saying that this is what we heard, this is what the students said, and so on. So in my situation at an elementary school, I always have the student state exactly what they said, and why they said it. Because then the parent hears it in their own words. Now I might have taken notes, but I ask them to repeat it for their parents so that they don't think that I changed the wording or anything like that. Sometimes they'll say, no, I don't want to, you do it. And then, of course, my relationship or rapport with that student, I would say, well, your parent, I think they want to hear it from you. And then the parent will kind of encourage them. It's okay. You're in a safe place. You're not in trouble. And then they go ahead and repeat it. That way they know that you aren't saying things, for that student and that you aren't changing the wording of the student. You just let them say it exactly the way that they said it to you. Okay, here's some challenges with risk assessments. It shows that they have not been a predictive value, and they have a high false positive rate. So we want to be careful with those. That's why it's important just to let them say it. And then just, we have a new notification that lets the parent signs, and we keep the original and give a copy to the parents with resources on the back. And what that does is just validate that you had a meeting based on that subject. Because the parents will say, yeah, I came to the school, but that's not what she talked about. She talked about this, or she talked about that, or she said it wasn't a big deal, or he said it wasn't a big deal. So our documentation specifically states that we conducted a risk assessment and that we're releasing the student to the parent, and all these people were notified, and that is the way that it's handled. And that's part of our protocol on our policy and procedures. Many suicides occur in individuals previously assessed as low or no risk, and as students often minimize or deny suicidal ideation. Medical professionals increasingly question the accuracy you and the utility of the suicide risk stratification tools, and school counselors' utility of the suicide risk stratification tools. And school counselors depend on self-reports, which are often unreliable due to the students hiding or denying true feelings. Quantifying risk can give a false sense of safety and may lead to negligence and necessary parental notification and intervention. So again, when you're doing these notifications, you definitely want to make sure that you're not giving too much information, but that you're giving enough information so that the parents can definitely assist the child at home. So you won't ask, do they have access to guns or anything like that? But you may say, I need for you to ensure that they're not left alone, that they won't be here, because that's also a detriment. Many times the parent will say, I have to go back to work. They're okay. I talked with them, and they don't have any more knowledge than we do, whether they will actually carry out that threat that they made or the conversation that they had. So, you just want to make sure that you equip them with any um, tool that they can have so that they know. And also, especially when they're going between two homes. I had a recent situation where it is a custody issue, and so the child is going between two homes. So the person that I got in contact was not the person who he would be with for the remainder of the weekend. This occurred at 2 o'clock on a Friday, and so the mom had to contact the dad But the dad came back for the reentry meeting, which I was really thankful for because I've never met him before. And so that was important in him hearing it from the school and not just hearing it from the mother because they don't see eye to eye on many things. Um, so when we're giving our parental response to to suicide ideation, we want to communicate the suicide risk clearly. We want to address parental doubt and fear, and we want to provide resources and encouraging actions. So just like I stated with the case that I just gave you, the father doesn't feel like may feel like we're doing a little bit too much. However, because he's not in contact with us and he's in the child's life, but his job takes him away from the school atmosphere. So he's very disconnected from the school atmosphere. So he's hearing everything from the mother. And of course, when you're divorced, sometimes you don't see eye to eye on things. And so he sees his child under one way, but we see him differently. And so we're trying to provide resources. In my situation, this is the third time the students made a threat. So again, I've never met the dad until this time. So I think it was important, and I'm glad that the mother was able to get him there for us because now he understands that the other two were, and we've had an escalation in that. So we went from threats to actual him cutting his fingers with scissors in the classroom. Okay, governmental immunity and what that means for us as school counselors. We're public employees and we're from personal civil liability for acts performed within our employment scope unless willful or wanted misconduct occurs. With negligent and suicide cases, most courts have ruled that school counselors and districts are immune from liability unless gross negligence or intentional harm is proven. Some key cases like Fowler, Sozeki, and Grant and Valley View upheld immunity even when the counselor failed to notify the parent of suicide risk. Some states have exceptions where immunity does not apply, especially in those cases of willful or malicious acts, such as sexual abuse by school counselors. Governmental immunity encourages school counselors to follow protocols. It also highlights the importance of documentation and adhering to ethical and legal standards. So again, it's important for us to make sure that we are following our ethical and legal standards. Intentional infliction of emotional distress is a conduct that causes severe emotional trauma beyond the ordinary rudeness or offensiveness. So, extreme or outrageous behavior by someone in a special relationship, like a school counselor, can qualify as that intentional infliction of emotional distress. Such conduct violates ethical standards and can result in legal actions. School counselors have to maintain professional boundaries and respect student dignity to avoid those claims. An example of that is a counseling intern posted a mocking photo of a student online causing emotional distress. So, and it could be, I'll tell you one that happened many, many years ago and you never think it's going to happen. But it was with a fifth grade student, and I work with this particular teacher today, and she did it over 20 years ago. But many years, teachers try to give out awards to everyone, and there's usually about 30 kids, anywhere from 25 to 30 kids in a fifth grade classroom. And she had a particular student that she wasn't too fond of, and she had to try to figure out how to give him an award. The award that she came up with was the Pig Pen Award. Not in the best um, you know, was very distasteful, and the parents found it very distasteful. So she didn't have any legal consequences, but she did have some district level consequences. Okay, sexual misconduct and leading and legal repercussions. School officials have the duty to protect students from abuse, including sexual misconduct by school counselors. This duty includes exercising ordinary care and hiring, training, supervising, and terminating personnel when necessary. Failure to act on knowing risk or prior misconduct can result in legal liability for the school district and administrators. Cases demonstrate that ignoring warning signs or past incidents of the sexual misconduct is considered negligence, and supervisory personnel must take reasonable measures to prevent abuse and protect students in their care. So the newest protection with the sexual misconduct, you know that it's up to 40 years. So people can come back 40 years later with that sexual misconduct. And so um, you could have been the school counselor in charge when all that was occurring, and you get subpoenaed for this court case. And you may have never known anything about it, but they will subpoena you while you're sitting at home enjoying your retirement. So this is important because our district will give us, all of the contact information to bring us to that particular lawsuit, especially if there's any notation in the student system that they end up putting on microfiche over time, stating that you made a notation somewhere in the log entries or somewhere stating that you had to speak with this particular um, person in regards to sexual misconduct, and you said something, or something was seen as inappropriate, because that's the grooming. That's what they consider the grooming stages. Eating disorders. So this is just a case study. Karen, a seventh grader, is suspected of bulimia. She confides in her school counselor but fears parental notification due to family issues. So what should we do? What happens if the counselor tries to intervene without contacting the parent?
Well, the student is harming themselves health wise, so I would think they need to notify the parent.
Hmm. Anything else? Anybody else have any thoughts? It would be a legal risk, yeah. Let's just say she passes out, okay? And she passes out a day or two later, or maybe a week later, or maybe a month later. So she has bulimia. She's been dealing with this for a very long time. Now it's hitting her physically. And as it's hitting her physically, she is starting to show other physical signs like passing out, or she's on a trip, and a school trip, and she passes out. This can be a legal ramification for the school counselor, because the school counselor, a whole month has gone by, and the school counselor hasn't notified the parent to where the parent can get support for the student. She's relying on the fact that maybe that the student can get help for him or her for herself, but she probably needs more support with it, because she may not see that she has a problem, and she may not follow through with the support that she needs to seek to help herself. Okay, so um, the big thing here is that the counselor is looking at confidentiality. The student asked you not to contact the parent. Is that something that we can honestly do? Can we? No, we can't because there's three reasons why we can't, right? What are those three reasons? Go ahead and type it in the chat.
Sure. Oh, sorry.
Go ahead and type it in there. I want to make sure everybody knows what the three reasons are. But what is the three reasons why we must breach confidentiality? Good. Thank you, Daniela. You usually got to rattle off. These three things you must rattle off at all times. All right, perfect. Okay, those are the three reasons. Everybody's pretty much got them now. If you're hurting yourself, you're going to hurt someone else, or someone is hurting you. So this falls under that because you're hurting yourself. You're causing harm to yourself, which Danielle already mentioned. And so we should have told the seventh grade, I'm sorry, I can't. There are three legal reasons why I cannot um, help, keep this confidential. And you have your confidentiality rules up, right? And this one classifies under you're hurting yourself because you're not eating enough, you're not healthy enough. And so therefore I can't do that. We have to get you help. And your parents are the people that can help you, by informing them. And you don't have to worry about any breaching of confidentiality. She may be upset with you. You may need to take some time before you actually make the phone call. Um, and then the only other thing that we have to think about is, being able to make sure that the parent comes up and talks, supportively to the child. All right, let's see, moving on. So when we're making connections, we want to make sure that we're discussing the differences between negligence and malpractice and their implications for a school counselor. We need to explain the components and importance of the standards of care in our professional practices. We need to analyze the concept of foreseeability and how it should guide decision making and risk management. We need to explore governmental and sovereign immunity and its impact on liability in school counseling cases and reflect on how these legal concepts influence our ethical responsibilities and our daily practices. Right? Okay, what's happening? My whole thing is frozen. All right, let's see. There we go. All right. Give me 1 second here. So I want you to take a minute and take a look at your book while I send you something via email. And what I'd like you to do is try to come up with a theme that you're thinking about for your final assignment, something that you're interested in that you're going to look for your court cases, or maybe you've already done that. And when you're done, put your topic in the chat for me, please. Okay. Monisha, underserved population isn't one of our legal themes because when you say underserved, it doesn't really cover anything. We're talking about the legal and ethical for for our final assignment. So, what theme in the book, like we talked about duty of care, negligence, sexual abuse, that that's what we're talking about. Whether it hits an underserved population, that's fine. Mhm. All right. Okay, let's see where we are. Let's see. Yes, sexual misconduct is a good one. Due process. There's no student discipline, but due process is just, but that's going to be hard to find. I'm going to tell you that one's a difficult one. Of course, bullying, cyberbullying, that's a good one. Mandated reporting. So we're looking at child abuse. So I would just, instead of just saying mandated reporting, I would just say child abuse, like, so that covers a larger group and it'll be easier to find. Academic guidance is about the only one you're going to find. Academic guidance, and which falls under negligence. Otherwise, you're not going to find anything. All right, so I have, how many do I have? All right. I'm doing this for a reason. So you're not searching for things later that I'm not going to accept or that does not count. So if you're, I really need you to think about it. So foster children and education, that again, you have to be looking at that's the group of students. That's not the actual legal and ethical standards that we have to stand by. Okay, so it's duty of care, it's sexual abuse, child abuse. Those are the themes that are in our book. Who it hits is what you keep targeting. You keep targeting the group of children. Yeah. Confidentiality, student privacy, duty to protect. All of those are correct. All of those are correct. All right. I sent you, keep going if you haven't put yours up there. I just kind of want to, like I said, you should be researching right now. You should be looking for your documents, and we're going to practice trying to find a document right now. So I want you to know how to go about looking for a court case. And so it's important for you to know how to get that court case. Negligence, like we just talked about, duty of care, negligence, all of those things that were in that chapter. Those are the two overarching themes, and that'll be great. So, academic advising falls under negligence. So, yeah, so that kind of goes together, right? Good. Okay, excellent. All right. Open up the document I sent you. This was a school shooting that happened. Most of you guys might remember it. I've got to open it up myself now because I had to close it to send it to you. I know this one's not in the book, but all right. Kind of take a look at that one, read over it, and tell me what you see. How many people remember this case? 2021? No, it's in the news and everything. It's big.
I just watched a documentary on this like last weekend.
Oh, did you? Okay. I didn't even know that they had one. All right. Your thoughts. Tell me what you see.
I feel like the counselors didn't act fast enough. Them giving that 48-hour window um, intervened with the kid getting help. And there was clearly warning signs that they should have acted upon earlier, in my opinion.
Okay, but now go back up to, okay, go ahead.
I have a question. Where did you send the link?
Huh?
Where did you send the link? Did you say you were going to send a link to that case?
No, not yet.
No? Oh, okay. Sorry. I thought you were going to send a link.
You have the paper in front of you, right? In your email? Your school email?
Okay, so it's on our school email.
Yes, yeah.
Okay,
It's just a Word document.
got it. Okay, thank you.
Okay. Okay, no problem. Thank you for asking. Um, all right. So you said that, oh, did you see the part where they said they instructed the parents that if they didn't take Ethan home and arrange counseling within 40 hours, they were going to call DPS, right? You saw that. And you said, so you're saying they didn't act fast enough. What could they have done differently? Because remember, if you scroll back up to the top, and this is really important, they didn't witness any behavior. They didn't see any leading behavior that day. That he was calm, he wasn't saying he wanted to go back to class, you know, that they didn't have a reason to hold him. Or they didn't have a reason. He hadn't done anything that day to where they could say, I'm sorry, he can't stay at school. So they didn't have, I mean, because if you're saying that you can't stay at school, you should be doing some more stuff, right?
But what wasn't he drawing things that he wasn't that were alarming though? Because that's what I'm reading.
Right. So he drew some things, and
Mhm.
when they did their risk assessment, they observed it and they said that they informed him of the violent behaviors, which means they were expressing a concern, right? They didn't have prior notification, like this wasn't the fifth time or the sixth time where this occurred. So remember, you can't send everybody home for every little thing that they do, right? So, but the right thing that they did do was what? Contact the parents in person. Now, who's the people that they said they refused to take him home? So not only that, the school counselor and the dean suggested to take him home and watch him. But they were like, no, they were going through a divorce. They were having issues and they didn't want to be responsible for him at home. Now, this is a carrying state, with weapons. So it's different than how it works here also. So we have to keep that in mind too. So they had that he was browsing ammunition on the day before, but that didn't come out until the court cases. Does everybody see that part? It says that the school officials have stated that the counselor and the dean acted according to their training and did not witness behavior that indicated that he was planning to cause harm to others while meeting with them at school that morning. So that was the big concerning thing. And the fact that they advised them both to take him home for the day. So as a result, he ended up having a gun in his backpack, right? He goes out into the hallway and shoots those four people. So some things could be coming up. Do you see like foreseeable harm? Did they know he had a backpack? Did they know he had a gun in the backpack? No, they didn't. They had no idea. And since the drawings didn't lead them to search and seizure, can you do a search and seizure? What's the law for search and seizure?
Don't you need a warrant to go through someone's property?
Reasonable cause? Reasonable cause. Do we have reasonable cause? Can we connect? Drawing a gun means you have one?
No, but they said the backpack was heavier than normal.
Yeah. It was heavier than normal, but would they have, I mean, how many people would have done it? I mean, it's kind of like some people might have said, "Can I see your backpack?" Open up your backpack. That could have been something. Or we'd like to see your backpack. We want to make sure you're okay and that you don't have anything. I mean, will you show us your backpack? Those are all things that could have been stated, but I mean, is that in their practice? Is that something that they would have done? Now, any thoughts? Go ahead.
Could they have asked the parents to open it? Because I'm just like, if the kid's like, no, I refuse, could they have asked like mom?
You could ask the parents, but if the parents said no, you're still in the same position, you know. But I think that's good, Hannah, because I think maybe the parents, once the shooting happened, they called back up to the school and stated that they thought that their son was the one who shot because they went home and found that the gun was gone. So when that happened, maybe that would have been something. But again, we're talking about the counselor. I mean, these are good things to think about. But I'm just saying that, um, you have to also see if someone says no, if they say no, you can't do that. Now, where I work, they would open the backpack for me. But it's all different. Everybody has a different way of getting you to do things that, without them saying, oh, that was wrong, you shouldn't have done that, so on and so forth, right? So it's just different. Okay. Now I want you guys to go to the actual, if you go all the way down, I have the appeals court opinions, and I have the connections to um where you can open that up or copy and paste that into the actual district, the actual court case. So I want you to copy and paste that into the court case so you can see the document. Everybody have that? And voila. There's your court case. So what is this one under? Negligence, right? Gross negligence. Everybody see the theme? See the connection? Everybody see the process and what you're going to be doing? Anybody have questions? And this one is not in our book because it happened in 2021, right? So this one is not in our book. So now I would need 2 more cases on negligence to complete that final assignment. Questions, concerns? Everybody's just looking at me. Are you guys with me? Hello? Yeah.
I'm confused. Where are we supposed to be pasting it?
Oh, you can just copy and paste it into the internet, and then you're going to see the court case pop up.
Okay.
And then when you see the court case pop up, you'll see how to get those documents. And then you'll have the whole court case. That's a summary of the court case. Then you'll have the whole court case. And that's what you're using to write your actual paper. And you'll need two more on the theme of negligence. Not necessarily, following the same. It doesn't have to be a school shooting. It doesn't have to be just negligence. Everybody got that? And it doesn't have to be the same level. If this one is high school, it could be a different level. It doesn't matter. And then you have your 3 court cases on negligence. And then you begin to write your paper. Questions, concerns? All right, so next week, for our next live session, you will be selecting your group, where you'll do a group presentation on our historically underrepresented students, right? Marginal students, marginalized population. And so that marginalized population, you're going to select one of the categories that's listed on the page, and you will do a presentation on that group. And you'll answer the questions, and it should be in some format of a PowerPoint, Canva, whatever you use, but a slideshow presentation or a deck is what they call it now. And then you're going to go ahead and present that deck to me and to the class for our 5th one. No, we're not doing this one in groups. It's all individual. We don't have any group assignments due this course. Okay, and remember, you're just answering those questions. So with those questions, it's around 5 to 10 slides, answering the questions and making sure you have enough information, and then reporting that information out to us.
I have a
Right?
question.
Mhm.
Sorry.
No, okay.
So we cannot use that case that you just gave us. We would
No,
have
you
to
absolutely
pick 3.
can. You absolutely can.
Okay. But it would count towards the 3 that we would
Yes.
pick.
Mm-hmm.
Okay.
Mm-hmm.
Thank you.
Yes. Okay. Questions, concerns about your next few assignments? So next week not next week, week 5, you will come to class prepared to present on your marginalized population. And you can select anyone on the paper. Okay? Okay.